Right, now, one of the accused in the Senzo Meyiwa murder trial is going to be in court today to learn his fate. Bongani Ntanzi awaiting the outcome of his bail application. Now, already having spent a couple of years in jail and applying for bail, it was last October. Let's head over to senior reporter Silindelo Masikane. Hello to you, Slee, as well. And it is astonishing that it's now well into 2023 and questions still not answered around the death of Meyiwa. But I know you also have one of our regular legal experts with you, Slee. Good morning.
Morning, Gareth. Yes, we find ourselves back in the North Gauteng High Court, where we are expecting the bail judgment to be delivered just after 10 a.m. this morning. Now, Bongani Ntanzi applied to be released on bail in October of 2022, and being accused of murder, the onus was on him to prove why the interests of justice permits his release on bail. He also told the court about the fact that he was never afforded the opportunity to apply for bail, despite having spent about 2 years in incarceration awaiting trial. And so in October, we saw that application being made by his former legal representative, Titi Tobane. And I remember back in February having a conversation with Mr. Tobane, and he had indicated he was going to write to the Office of the Chief Justice because at that point it had been a couple of months already of waiting for this judgment to be delivered. But to unpack the proceedings that we are expecting this morning, I am joined by legal expert Mr. Marius du Toit. Thank you once more for your time. Perhaps maybe speak to me about how normal it is to wait about 7 months for a bail judgment.
Morning, Slee. Lovely speaking to you. First and foremost, we must say that the bail application by its very nature is an urgent application. So it's something that should attract the urgent attention from a court. Now, 7 months sounds completely irregular to me. I can't understand why there would have been such a massive delay. Having regard to the fact, maybe this is slightly different to your normal bail application. And the reason why I say that is, normally when I'm arrested, Slee, one of the first things that the court would explain to me is, listen, sir, you can apply for bail. You are facing a premeditated murder matter and an armed robbery charge, so it's a Schedule 6. You have to prove exceptional circumstances before you can be granted bail. And then within 2 or 3 weeks, I can bring my application. Now, in this instance, he's already been incarcerated for a period of up to 2 years. And now he's only applying for it. So he had all the opportunity of bringing the application. It's not like he can argue and say, well, it is something that must immediately be heard, because he's already waited 2 years. That being said, of course, one has to keep in mind that it's still by its very nature urgent in the nature of the bail application. And for that reason, you would have expected the court to have granted or at least given a verdict in this matter. So 7 months sounds a bit long to me. I mean, I can't understand why it would take 7 months for a court to consider, keeping in mind all the evidence has been presented thus far, and he's been considering it as a presiding officer. Typically, I would wait. If I was the accused, I would wait until the state case is closed before I consider bringing such an application, because who knows what other evidence is still to be adduced. So maybe slightly premature on his part, but having said that, it's still untoward to wait 6 months or 7 months.
Mr. du Toit, then maybe speak to me about Bongani Ntanzi's options, perhaps if he is acquitted of the charges. You know, we are expecting the trial to resume next week, but hypothetically, let's say, he's acquitted of the charges, and could he perhaps have the option to sue the state for the time he spent in prison?
So absolutely, Slee. You know, when you are arrested, the cops must have reasonable grounds to suspect that you've perpetrated a Schedule 1 offence or you've committed an offence in their presence. In this instance, armed robbery and premeditated murder is a Schedule 1 offence. So the first thing is, did the state have reasonable grounds to initially arrest you and detain you? Once that hurdle is surmounted, then the next test will be, did the state, in postponing your matter, and perhaps not you're not applying for bail, did the state maliciously prosecute you? Or can we say that the investigating officer and the SAPS have deliberately placed evidence before the court which would have created a misconception as to whether you should be incarcerated or bail denied. Now, our Concord, I think about 2 years ago, gave a ruling that specifically said that the state, by virtue of the SAPS, the Minister of Police, remain liable past the initial phase of the reasonable grounds for which they arrested you. If, however, there's evidence and you've been incarcerated for 1 year, 2 years, or 3 years, the SAPS or the Minister of Police will remain liable. So at the end of the day, if he has been, number one, if he's acquitted, and number two, we see that the evidence against him was so weak that he should never have been prosecuted, well, then, of course, he would have the right to pursue a civil action for the detention. And I can tell you, if he's been incarcerated 2 years, or let's call it 3 years by the time the matter is over, chances are he would get a substantial settlement from the state should he be successful. So absolutely, he would be within his rights to pursue a civil action. The tests are slightly different to when you initially arrested versus the continuation of your trial, but without a doubt, an accused has a right to pursue such an action and to, if he's successful, to be compensated fully for that.
Lastly then, Marius, just quickly, wouldn't Ntanzi then be able to appeal the bail judgment if it's not in his favor?
Absolutely, Slee. So you have the right to appeal any decision that's final. In this instance, the bail being denied is a final decision, and you absolutely have the right to appeal a bail decision that goes against your wishes. In this instance, it is something that once the typed record is obtained, the accused will have to place it before the appeal court. You don't have to ask for leave to appeal a bail decision, generally speaking. And as a rule, you would be able to be heard on appeal within a short space of time because of its very nature that it's urgent. However, in this instance, the bail hearing was done by the trial court, and that would make the process a little bit longer because you'd have to have the whole record transcribed. You'd have to place everything before the next court. So I think it would definitely cause a delay in him actually being heard. And keeping in mind, we're dealing here with a person that's perhaps exhausted his financial means in pursuing his acquittal in this trial. Who knows if he still has the financial means to pursue a bail appeal. So the cost, it will be a costly affair like all appeals. But it should be something that he would be able to bring. It should be able to be brought within a reasonable time. It should be considered, hopefully not 8 months, but it should be considered within a reasonable time. And if successful, of course, the appeal court will permit him to bail.
Thank you so much for your time this morning. That is legal expert Mr. Marius du Toit unpacking what we can expect in terms of the bail judgment and the proceedings, which are expected to start after 10 a.m. this morning. Back to you in studio.
All right, Slee, thank you very much indeed. In studio with updates here on eNCA, also on Twitter as well. You can go and follow Slee in case you can't be with us. Of course, we'd love for you to be with us, but if you can't, we understand. But you can follow eNCA on Twitter, at eNCA, also Silindelo Masikane. Just go look for her. It won't be difficult because everyone's following her on Twitter for the updates from the court cases that she follows.